welcome those of you who have arrived so far. We're going to give it a little bit more time. We have a lot of registrants, so you're being admitted slowly. So we'll be back in a minute. Okay, thanks to all of you who've shown up on time. As people are still coming in, but we're going to go ahead and get started. So thank you very much for coming. Good afternoon, everyone. I'm Bruce Mcconnell, a longtime actor and advisor on international cyberspace policy and security. I'm also a board member and distinguished fellow at one of today's hosts, the Stimson Center. For 3 decades, Stimson has been a leading voice on urgent global issues. Today, as changes in power and technology usher in a challenging new era, Stimson is at the forefront, engaging new voices, generating innovative ideas and analysis, and building solutions to promote international security, prosperity, and justice. Our co-host, the Washington Foreign Law Society, was founded much earlier in 1952 to promote knowledge and understanding of international legal matters, comparative legal issues, and foreign law. This is the 4th in a series of events that the Washington Foreign Law Society and the Stimson Center have jointly produced to examine and discuss legal accountability in cyberspace. Our first program looked at state accountability, considering the work of the United Nations to further norms for responsible state behavior and in cyberspace, and the use of sanctions to discourage bad actors. And our most recent session covered the insurance industry and its accountability for loss coverage for what some considered warlike acts in cyberspace. Today's webinar is being recorded and will be available with the earlier programs on the Stimson Center's cybersecurity webpage and on the WFLS events page. Those links will be coming up in the chat shortly in the Q&A. The program today will consider platform accountability, particularly for content. This is an extremely difficult topic at the intersection of cybersecurity, freedom of expression, privacy, legal liability, corporate business models, and conflicting national cultures and laws. We have seen the impact of disinformation on elections and on the uptake of COVID vaccinations on a global basis. The platforms find themselves caught in the middle of very powerful forces, being required to make quasi-judicial decisions on the basis of their terms of service. It's not sustainable for anyone. Fortunately, today we have the most excellent Michael Teodori with us to guide us through this minefield. Michael is the Law Society's chair of programs and a congressional affairs specialist with Italy's leading energy company, Eni. Michael?
Thank you so much, Bruce. It's a real pleasure to be here today with you all moderating this timely and important discussion. Let me first of all introduce our 2 wonderful panelists who have agreed to be with us today, and I'll be providing only an abridged version of their bio in the interest of time. The rest is on our website. Dr. Mariana Valente is the director of Internet Lab, an internet policy think tank based in Sao Paulo, Brazil. Internet Lab is active across the board in the digital policy space, working on issues such as freedom of expression, privacy, surveillance, access to information and knowledge, and data protection. Mariana is also a professor at Innsbruck University, where she teaches internet policy for business administration and economic students. She is a lawyer by training and holds a PhD in sociology of law from the University of Sao Paulo Law School, and was a visiting researcher at UC Berkeley during her PhD studies. She is also a member of TikTok's Safety and Advisory Council since earlier this year. Peter Fetelnij is Minister Counselor for Digital Economy Policy at the delegation of the EU to the United States in Washington, D.C. He has been a senior manager at the European Commission since 1998, and in his current role, he leads the EU delegation's engagement on all aspects of the broader conversation of digital tech. Prior to the EU, he worked on international assignments for the strategy consulting firm American Management Systems, and for the European Space Agency in the Netherlands. Peter holds a master's degree in communication engineering from the University of Technology in Graz, Austria, and is a senior member of the Institute of Electrical and Electronic Engineers. And before I hand it over to the panelists, allow me to provide a bit of context to our conversation today. Platform accountability, of course, as all of you who are connected know, is a concept that online platforms might bear some responsibility for the content that is posted on their website and hosted by them. In the US, the provision governing platform accountability is, of course, Section 230 of the Communications Decency Act, which is perhaps one of the most well-known provisions in the US legal system, and in a nutshell provides a broad form of immunity for online platforms while allowing them to intervene in the content that is hosted on their website. And it is largely credited with having allowed the early blossoming of the internet. There have been in the past weeks and months countless calls to update this framework, which is by now over 2 decades old, having been adopted in 1996. And calls have come from a variety of different stakeholders, both political parties, which is absolutely uncommon in this day and age, nonprofits, the private sector as well, and so on. And of course, there is little agreement on what an updated framework should look like. And so we thought that it could be an interesting idea to look at how other jurisdictions in the world are looking at these issues. And we chose Brazil and the EU for 2 reasons, essentially. 1, because of their size and because of their user base, and 2, because there have been recent initiatives in both the EU and Brazil that are definitely worth taking a look at. And so with that said, with the panelists' permission, and we've agreed that we'll be on a first name basis throughout the conversation, I'll go ahead and ask the first of what I hope is going to be a long series of questions. And so why don't we start by setting the stage for the conversation and talking about what is the status quo in the EU and in Brazil on platform accountability, how it differs from what we see in the US, and what are the recent steps undertaking by your jurisdictions in this space. And perhaps Mariana can start, and then we can move on to Peter.
For sure. Thanks, Michael. I'd also like to thank the Stimson Center for the invitation. Thank you all who showed up. So when it comes to Brazil, the framework that we currently have is the framework established by the Marco Civil, or the Internet Civil Framework. It's legislation from 2014. Perhaps many of you have heard of it because it was a process. It culminated from a process of public consultation, and it was an all-encompassing legislation to take care, let's say, of human rights online. And when it comes to platform accountability, many people call the Marco Civil model the human rights model. It's a model through which platforms become liable when they fail to act upon a court order ordering takedown. So the idea is that courts have a more prominent role in deciding when a piece of content should be removed, because a court is in the right place, let's say, to consider the different rights that are involved. But just as the US framework, the Marco Civil does not prohibit or in any way hinder content moderation. And that's actually an issue, because since it doesn't address content moderation at all, we're now currently discussing 2 proposals that address content moderation in different ways. Since last year, we've been discussing this fake news bill that's actually much broader than fake news. It has become much broader than fake news over the discussions, and it sort of establishes a due process that platforms should undertake before moderating content, having the user at the center. And we're also discussing an executive order that supposedly will pass soon, that actually prohibits many of the moderation activities that platforms undertake right now. And that comes from visions that platforms are doing too much in censoring speech. That's legislation that has many problematic points, in that it might also be a problem for establishing a safe environment and a diverse environment, but I guess we can discuss that further. So these are the 2 pieces of legislation that are trying to address these points that the Marco Civil doesn't solve.
Peter, would you like to provide a framework of what the EU was looking at and what the rules look like now?
Many thanks. First, many thanks for having me for this conversation. I'm really looking forward to. I think from a legislative or regulatory perspective, we have in place in Europe as well similar rules as you find in Section 230. We call it the e-commerce directive. It's a little old by now, but we'll come to that later. We have a code of practice in place since a number of years. All major platforms conform to a code of practice that's a self-regulatory voluntary tool. So we see that as an element of our regulatory landscape. And of course, as Mariana also mentioned, there's quite some jurisprudence available by now on a variety of issues which are coming up in the space of this information on how do you deal with content online. So from a regulatory perspective, something is in place, something is working. Now, the other status quo is that 83% of the Europeans think disinformation threatens democracy. 63% of the younger Europeans come across fake news every day. We see that this we have put in place do have an effect, but not necessarily are enough to get us where we want to go. And we may come to that where we want to go. I think what the lawyers among us will appreciate that in Europe, we mostly act on a precautionary principle, which is not necessarily how legislation or drafting legislation in the United States works. And in fact, the precautionary principle is enshrined in Article 191 of the Treaty of the Functioning of the European Union. So this is also one reason why the Union has to act. And when we see statistics like that, and there's a broad consensus that action needs to be taken. Now, I'm sure we have opportunity to explore a little bit sort of what type of action would be a useful way forward. And I would like to leave it a bit here with an introduction.
That's terrific. Why don't we take a step back and kind of understand and try to think about in general terms, what are the most significant issues and threats that an online accountability framework must address in the short terms? In other words, what are the perils of not implementing a stricter platform liability standard, or what are the perils of leaving in place a system that, as the one in the US, is by now about a couple of decades old, and therefore pertains to a moment in time where the internet was completely different from what it is right now? And Peter can perhaps go first, and then we can get some input from Mariana.
Yeah, no, I think what I think we should also look a little bit what we talk about, you know, and I think, at least from a European perspective, and I'm not suggesting that's the way to look at the world, but we look at illegal content. So there shall be rules around describing how do we deal with illegal content. There's disinformation. In fact, we have made what disinformation is, and I would like to share with you how we see it. We consider disinformation as verifiably false or misleading information, which is distributed for economic gain or intentionally deceiving the public. So you see the economic gain, the intent, verifiably false. So these are elements in there. There is misinformation, where people promulgate or disseminate information which is wrong, but they are not necessarily aware of it. So this can happen as well. And then, of course, the overwhelming majority of content out there is of no concern. So that's perfectly fine. So I think we talk about this a thin sliver in terms of quantity of the information we would like to address with our legislations. When you talk about the perils of not addressing it, I think what we see today, and I think increasingly we realize that we are actually not living in a very innovative world. We are not seeing the economic gains, the societal benefits of many of the technologies we have today. We don't see that. There's very little which shows up in statistics or in a better quality of life. So I think we have to tilt back a little bit, make sure that we regain the trust which has been lost with the users. Because if we don't, essentially all this transition, all this talk about transitioning to a digital society, a digital economy, it's not going to work. It's not going to work at all. So we have to do it with the people and not necessarily against the people. And I think there is quite some opportunity for policymakers to come in and turn a few knobs and see if they can optimize the system. Concluding that question, I don't think there's the silver bullet right now out there where you say, you know, if you do that, everything will go away, you will be fine. However, I think there are a number of smaller, meaningful steps we can take where we know they go in the right direction.
Can I take that?
Take it away, Mariana.
Thanks. So I agree a lot with many of the things that Peter was referring to. And I do think that when we're speaking of platform accountability these days, we're very much speaking of disinformation. That's certainly a major concern. And the way I see it broadly is that I think it's inevitable that we'll have to reach new regimes different from the ones we had 20 years ago, especially because the internet has changed so much. And I think that these new regimes, they'll have to be sensitive to different situations and establish certain duties for digital platforms before, even before ruling out, let's say, liability in all cases. And because platforms have become so central to communications, I find that they should have to comply with certain standards of safety, and that thinking in regulatory terms that can be tied to platform accountability. I'm also thinking here that I'm remembering that David Kay, former UN rapporteur for freedom of expression, he affirmed so many times that guaranteeing freedom of expression means guaranteeing the means for everyone, and especially marginalized groups, to speak. And I see that there have to be duties regarding that. Otherwise, we'll be speaking of freedom of expression as an empty slogan. And I'm saying that because I think that's something that goes beyond the discussion on disinformation that's been kind of ruling the public debate lately, right? And I also want to echo Peter in that it is not so easy as it sounds. I think we're seeing all around the world legislation that's proposed that comes with vague language, for example, and that could negatively impact other rights, users' expressions, freedoms, and even the freedom of marginalized populations. And also that many times we can see the problem, but we miss the causality. So many of the problems we're speaking of, for example, they derive from market power and lack of other accountability measures, let's say radical transparency, for example. And we're always putting all the eggs in the basket of platform accountability in terms of liability, civil liability. So I think we should go to the direction of finding regulations that address the problem from multiple angles, and not just, for example, the section 230 of the CDA.
There's so many points that you've raised that I'd like to touch upon. Let's perhaps proceed with order. And so again, on a more, let's say, general level, at the end of the day, the issue of platform accountability is one of balancing, right? It's a balancing of, on the one hand, the need to guarantee freedom of expression writ large, and on the other hand, the need to ensure that a framework is in place for the digital space to be a healthy space, right? And so my next question to you is, where do the checks and balances lie in the process of adopting, let's say, stricter or updated rules for platforms? How do we make sure that platform accountability rules, if we're really looking in that direction, don't slowly slide into content moderation rules, which of course could be used in very different ways in very different jurisdictions? And I guess, Mariana, you could start, and then we can have Peter. And I think you're muted, Mariana. I think you're still muted. There we go.
Thanks. So that's a very good question, and I think there's no easy answer for that. I think we have to have clarity on the rights that we're pursuing and avoid easy solutions, as I was saying. I think we have to have a clear definition of the problem, a diagnosis, and a clear-cut vision of what we want the internet to be. And I really enjoyed when Peter was saying that we need, for example, the the economic benefits of the digital environment really reaching citizens and businesses, and going back to that vision, let's say. And one of the things that I think is a way to go in that direction, I mentioned before, right, that I think there are many entry points in legislation. That when we're speaking of the current problems, we should be speaking more of behavior than of content. And I'm saying that because it seems like we've been discussing regulating content for so long that we're kind of addicted to it. And it's not that we should not discuss content, okay? I think there's no way we can proceed in this environment without discussing content. But there's something that's new, which is the kind of coordinated behavior that's behind many of the problems when we start to make a diagnosis of the problems we're going through. And I think the most creative pieces of legislation, they're trying to address that. They're trying to address architecture instead of just liability. They're trying to address market power in different forms. They're trying to address algorithms. And they're also trying to address that what platforms do regarding users' behavior. And that's a creative way to go, and I think that's a way that avoids many of the problems that we might incur into when we're speaking of regulating speech, which again, I think we also should. But that's a much more, let's say, dangerous area to regulate because of the multiple rights involved. I'll give it to Peter, see what he has to say.
I think I like a lot of what you said, and I think it's a good idea. But nevertheless, a lot of things can be done. I think just because we are in front of a very complex problem and we are not seeing completely through the problem for a solution, doesn't mean we shouldn't do anything. I'll give you an example. The Digital Services Act, for instance, is only concerned with illegal content. Now, many people may say, oh, that's boring now, illegal stuff is illegal. Now, that's a real problem in any economy worldwide. It's not limited to the European Union. They only chose to take an action. So we have to remove illegal content, whether this is content, products, or services offered online, makes little difference. What is not allowed offline is also not allowed online. So we can put in place rules which not only limit, but let me say the word, which eliminate illegal content online. Now, by putting in place those mechanisms and these rules, companies are in a much better position to actually understand what is ongoing on the platform. And I want to come to a point that I'm afraid we actually have no idea what we talk about. We don't, because nobody of us has any access to the real information. There is no, at least definitely not in the European Union, but also here in the US, the access for researchers to data, to conduct research over long and meaningful periods of time is not there today. If it is research, it's punctual, certain things are done, but we need to understand the problem much more in depth. And this is also one of the things we would like to address with the Digital Services Act. We want to ban illegal content, that's clear. I mean, I don't think it's very controversial as a concept. But at the same time, we want to create the ecosystem which deals with problems which go beyond illegal content. And one of them, for instance, is that researchers need to understand, need to have access to this content and need to be able to study it in order to advise the policymakers for conducting better policies and investing in better policies, but also for the general public for creating more awareness. Because Mariana, you are absolutely right. That needs many actors. The public sector cannot fix that problem. There is also the citizens who has to be part of the solution. And there's a whole host of actions, I think, and obligations which fall on a responsible citizens to deal with these issues.
Peter, Mariana, you both you both mentioned things like illegal content, disinformation, and similar phenomena. Given that sometimes legislation that is being considered in this space does have effects beyond the borders, right, of where it is being implemented, how do we pick and choose a set of values, right, where we say, well, we don't like this online, but we like this instead? And so how do we, let's say, decide which set of values will inform regulation of the online space, also considering that there is an underlying tension, I would say, between the philosophical underpinning of many of the major platforms, right? Your Facebooks, your Instagrams, your Twitters, that have ascribed to a largely American concept of freedom of expression and ways that the government should be intervening in the freedom of expression, and obviously the jurisdictions in which they operate. It's a very broad question. We can perhaps start with Peter, and then we'll move on to Mariana.
I mean, I have been following the development of the internet for a long time. And, you know, back 20 or 30 years, there was this idea the internet or cyberspace is independent from nation states and all of that. That is not true. That is not true. That's not the reality we are seeing today. So I think we also should be mindful and realistic in understanding that many of these technologies may work in different countries in different ways, and that's not a problem. That's not a problem. That's what we call customization. That's building a better system for the customer you have in front of you. I think the one size fits all was never there, was a dream of the early days and not useful as a concept in any case. So, and in fact, I mean, Michael, you know, you just told me before, and I hope I'm not spilling it, but you came back from Italy. You know, the major platforms function quite different in Europe. The content you're seeing is not exactly the same you're seeing here in the US, because there are a number of rules already in place in Europe, and companies are happily dealing with it. That's not the issue. I think the issue is that we have to make compliance to such rules close to zero cost. We have to push for the innovators in the smaller category of the platforms, let them grow. And for them, regulation is not the inhibitor for growth. The inhibitor to growth are other market infringing practices and behaviors by other platforms. These are the barriers to growth for the small platforms we are seeing. So I think it's perfectly right if different states and legislators come up with tailor-made solutions which they think fits their customers, fits their consumers, fits their citizens, who eventually elect them at the end of the day. So we do live in a democracy where people have the last say at the end. So
you take that to tell the audience, maybe some of you are not aware that from Brazil, I can file a DMCA notice to YouTube, let's say, to have content taken down. And I think that says a lot about how this environment works. It's the case very often that foreign law is being enforced when it comes to platforms, just because it's kind of inscribed in the architecture, right? So I can file the DMCA notice in Portuguese from Brazil to have content taken down, even if we don't have a law such as the DMCA. So I think that's one thing to address, and it's definitely not simple, but jurisdiction is definitely one of the things to address. But I think there's another layer to this discussion, which is the part on terms of service, which for many of these platforms are just global terms of service. They apply everywhere, right? And frequently, we're speaking, for example, of concepts such as hate speech that are not native to many of our jurisdictions. That's the case of Brazil, for example. We don't have a definition of hate speech, and many of the terms of service, they address hate speech. They say that they remove hate speech, and we have to end up finding a way to understand what that means in terms of our national legislation, how we can translate that. And those are issues that need to be solved with stronger national legislation, for sure. I agree with Peter there that countries are free to legislate. We don't have to have this idea that that you can legislate because it's a global internet and things like that, especially because you see that difference being made, as he said. But then there's this other layer, and I think that's more agreeing with what he said than disagreeing, that when it comes to applying terms of service, even if we're speaking of these global terms of service, how to make even these terms of service, which are global, how to enforce them, let's say, more equally in different jurisdictions, right? Because one other thing that we see is that problems which are of much importance in certain places are not seen as having as much importance, let's say, in smaller jurisdictions, particularly in the global south. And that means inevitably investing in personnel. For example, when we're speaking of content, right, of speech, to understand that a certain content is either illegal or it's just harmful is something that requires understanding of local legislation and of local context, right? Otherwise, sometimes you just can't see that something is harmful. And it's impossible for companies that are doing content moderation to do that without investing in personnel that understands local characteristics. And I think that's a challenge. And while I do think that countries need to address that, sometimes it's not that simple because many of these jurisdictions, they don't seem to have enough, let's say, economic power. That's not the case of Brazil. Michael mentioned that at the beginning, that we have a large user base. And although we're not as strong as European countries, Brazilian law is usually enforced in the national territory, but it's definitely not the case in many of the other territories. So I don't think I'm bringing many solutions here, but I'm trying to detail what this kind of problem is that you mentioned, Michael.
Thank you, Mariana. I think thinking about the problems is also a part of the process, and so that's also part of why we're here. In other words, thinking of what problems have cropped up in other jurisdictions that should be addressed, perhaps even in this jurisdiction. So we only have about 12 minutes before we move on to the Q&A, and this is a reminder to the audience to please submit your questions via the Q&A function in the chat, not the chat, the Q&A function. You touch upon a number of interesting conversation starters. Obviously, we've spoken a lot about regulation, legislation, and so on, and so top-down efforts, right, to fix and to address the situation. In your view, is there, and this is again to both of you, and then I hope to be able to get to other questions, but I think this is a pressing point that I wanted to address with you. Is there a better solution between top-down regulation, legislation, or let's say voluntary commitments, self-governing codes? For example, the EU has a code of practice on disinformation. Is there a value to be had in these, let's say, voluntary arrangements that companies might enter into versus top-down legislation and regulation? Or are those two systems that should or can perhaps coexist in providing a normative framework for platform accountability? And Mariana, you can start, and then we can move on to Peter.
Michael, the way I see it, they must coexist. It would be naive to think that legislators have all the answers and know what to do in all situations. I think it must be said that there are cases in which direct regulation is necessary, period. But then there are cases where what we want is for certain goals to be accomplished. It doesn't matter how. And there are many regulatory ways to make that happen, right? Like establishing goals that companies can fulfill in different ways. And I think there's space for experimentation there. I know that codes of conduct are criticized for having no teeth, but I don't see it as a problem as long as they're seen as a step towards other forms of legislation, as long as they're seen as a form of experimenting to see what happens, what comes out of certain commitments that are voluntarily taken by companies, and that proper legislation is found later that perhaps is more appropriate, that bringing perhaps things that weren't thought of as before. So I think they must coexist, and we can't think that it's going to be one or the other.
I think this was the reason why essentially after experimenting 5 years with a code of practice in the European Union, we decided to now table a regulatory proposal which catches everybody in this industry. This is the lessons learned simply translated into, okay, what are meaningful steps? Give you a very simple example. I think it's reasonable to ask every platform to have clear terms of reference and enforce them. So, I mean, that's a basic thing everybody would expect. In fact, many people ask, well, they don't. Well, actually, many don't, yeah. It's very easy to set up a platform and not do anything. Another one is knowing your customer. If in certain conditions, I think it's a reasonable expectation that a platform who is a marketplace knows the customers on their platform to a certain extent. So there are basic things which make a lot of sense for everybody in this space to reduce the risk. I'm not so sure. Let me say, I think, Mariana, I'm not disagreeing, but I think I would like to see the code of conduct, at least in the European Union context now, as something we want to also to move that forward, because it should always be this regulatory sandbox, the ambitious regulatory sandbox. That's the code of conduct. The actual legislation will always probably have to be a bit more conservative, as this is this stable law going onto the books. So you want to be certain you do the right thing on that one.
Mariana, do you want to counter, or should we move on to what I assume will be the last question of this session?
No, I think that's right. I think we should have all of these options together. I don't think one should rule the other out. I think I was mentioning more that there's this criticism that, well, a code of conduct is worth nothing because it doesn't have any teeth, you can't enforce it. And I think Europe has seen pretty well that in some cases you'll need to enforce certain things. In other cases, you can just establish goals, let's say, and see where it goes. I think there's one thing that's good about these regulatory sandboxes. It doesn't have to be codes of conduct. It can be other forms of regulatory sandboxes. That's also taking the company's participation, right? Because sometimes from the other side of the table, you're not seeing certain solutions or you're not seeing certain problems. And I think that's a way of reaching more creative solutions to the problems we already have. So yeah, I think they should all coexist.
I think that's a great segue to my last question now before we move on to the Q&A, which is looking back at the title of this program, can lessons be learned from across the globe? Well, are there any lessons that the US jurisdiction can learn from jurisdictions like Brazil and the EU when it comes to reforming or thinking of reforming online accountability? And we can start with Peter's experience in the EU and then move on to Mariana.
I think some experiences I would like to share we have made is that in this online user-generated content business model and the companies and how they function, this is the very same old business processes we see in these companies. It's all about making money, nothing else. And that's the function of a company. Seriously, I mean, it's the function of a company. And it's the duty of the officers of the company. So I'm not meaning that in a negative fashion. We just need to realize that. That's all I'm saying here. And there's nothing new under the sun. So which I think should give policymakers a bit more courage of they are dealing with a new variant of an old issue at the end of the day here. And this claim some organizations lay to the uniqueness of the sector and the difference is very often feels a little bit like a smokescreen, frankly speaking. I think we also can demand more from this sector, and we should, because I think we all want to enjoy more from a digital economy and society. So we want more innovation, we want more trustful technologies in this sector. So I think we should also push the companies and push the organizations, push researchers and innovators to deliver us more in this space. The history has not ended for the internet, neither for us as countries. So I think there's a lot to be made in this area. And perhaps now 21 is the time right after the pandemic where we can look back and say, well, maybe the last 10 years haven't served us so well, but we shouldn't dwell on that. We should just get our act together and try to see how we can move forward in the best fashion. So I think I see that more as a macroeconomic challenge than picking on the one or other company, which at the end of the day, actually, frankly speaking, in economic terms, probably close to irrelevant. None of these companies has any meaningful number of employment. So I think we should really focus on the issues. We should focus on getting technology into the hands of the people, broad and trustful. This is what we should focus on and not be bogged down by the one or other issue creeping up here or there. Mariana, for you to disagree. Please.
I think there's two things that I wanted to mention before and perhaps address what you just said, Peter. I think one of the lessons learned, now that we're seeing these pieces of legislation, of regulation coming out in Brazil, from our Marco Civil process, is that it fell short on regulating the full picture. It tried to address liability. It did not address content moderation, as if that wasn't an issue. And it was an issue already. And perhaps having this full picture, trying to look at the activity of social media, internet platforms from different angles is very important. That's something that we're seeing right now. There's a second thing that I think we learned from the Marco Civil case, that is that you can do legislation that's sensitive to particular values and particular issues. There's this one exception to the Marco Civil liability rule. That's an exception for content of non-consensual intimate images. And it's an exception to liability schemes in that platforms become liable after the victim files a private takedown request. And that's part of Marco Civil, because at the time that the Marco Civil was being discussed, a few suicides happened around the country. And this was seen as something that had a value that needed to be protected. But more than that, there was this idea there that there was no relevant right to be balanced, like freedom of expression, right? Like, what could freedom of expression be when we're speaking of, where would it be, right? When we're speaking of disseminating someone's intimate images without their consent. And I think that's the case when we're speaking of child exploitation too. So I think that sets an interesting line, which is interesting for this discussion, which is separating which are the difficult cases and which are the cases in which we don't want to establish, let's say, incentives for overblocking because they involve gray zones, but which are the bright line cases, right? And I think the Marco Civil did that in a very good way. When it comes to this broader view that Peter was referring to, I understand what you mean, Peter, but at the same time, I think there's something there in the equation, and I don't think you're ignoring it, just didn't mention it, which is that users also have rights online, right? And while I agree with you that we can't look at specific companies, I think we also have to be concerned about legislations that might affect that adversely when we're looking just at market structures. This is why I've been saying that, of course, we have to look at content, but we have to look at other forms of legislation. I know that Europe is trying to do that, to look at this problem structurally. At least that's how I see the DSA, the DMA right now, like looking at the problem from different angles. But I think people's rights and what it means to be online and to be able to express yourself online is something that has to be considered. And also, I don't think it has anything to do with protecting one platform or another or a business model. It has to do with protecting people's rights, and I think that has to be at the center too. And I'm sure you agree with that, but it's just about how to frame it, right?
So we're nearly at the 6:15 mark, so I will invoke my moderator powers and interrupt the conversation here, but not before I draft a very quick, I think, summary of what your last comments were specifically. And I think we can summarize it in three ways, which is we want a review or reformation of online platform accountability measures to be future-proof, to be values-based, and to be people-centric. I think is something that somewhat captures what both of you were saying up until now. And obviously, I think the diversity of the viewpoints is exactly what enriches the conversation, and that's exactly why we had this conversation here today. And so I'll leave it to Bruce for the Q&As. I know we have a number of questions from the audience, and if we finish questions, we can definitely come up with more on this side. Bruce?
Thank you, Michael, and thank you both our panelists for such great conversation. We do have some questions from the audience, and they kind of come around to two different areas. So the first one gets at what you all were talking about earlier about the kind of comprehensive approach that's needed, and not just focusing strictly on liability and strictly on content, but other kinds of behavior and, as Mariana said, radical transparency. So the question is, where is the line? To what extent can things like fighting disinformation with critical information and critical thinking rather than with censorship, and with these other tools like coordinated monitoring, coordinated behavior, shutting down bots, dealing with algorithms, to what extent can those things be used in addition to strict content regulation, especially when it's disinformation and not necessarily legal content? So either of you or both of you want to tackle that?
Ladies first.
I can start. I think that addresses something that's really important, that frequently when we're speaking of countering disinformation, even if we have a good concept, when we're trying to apply that concept to reality, it's not so easy. I'm just participating in a project right now in which we have to classify tweets, whether they convey disinformation or not. And I have a whole team of people working on that. We have so many doubts all the time, because the line is not always so bright. And I do think we have to be very wary of solutions so let me tell you how this fake news bill started in Brazil. The way it was proposed in its first version, it required platforms to identify anything that contained disinformation and send it to fact checkers and take down the content according to what fact checkers would say. That involved many operational problems, of course, but let's stop at the first part, identifying everything that is disinformation. This is something that the civil society in Brazil has struggled with a lot, because it's not so simple, and we have all the context issues that I was referring to and everything. So anyways, just to address it, I do think that counter speech, I think that's what the question refers to, is something that we must focus on. And I think that's important because of all these difficulties, but I don't think that means that we shouldn't regulate. We just have to find regulation that's appropriate and that doesn't fall easily into these mistakes. I'll stop here just because I'm speaking for too long.
In fact, our code of conduct our code of practice was complemented with a series of such initiatives. For instance, how can we strengthen professional journalism? We have seen newsrooms disappearing, newspapers disappearing, alternative sources of information disappearing, a huge centralization of this sector. So we have since years launched a series of initiatives on that, making journalism an attractive profession again. So there's a variety going that down track. Mariana has mentioned fact checking. And I also would like now to add sort of the strategic communication. If you as a communicator, you read social media, you're on the back foot. You should feed it. I mean, if you are strategic in your communication, if you go and fill this space as the first one, you have much better chances that fake news or disinformation will not gain the prominence it sometimes gets unduly. So, and I think it's a serious, and in fact, there's a long action list we have, what we did, because regulation may be necessary, but it will not fix the problem as a whole. So there's a whole host of other things we can do. Yeah, very good question. Thank you.
So thank you so much, both of you. The second kind of area of questions that's come up from the participants deal with this problem of independent review. Mariana mentioned fact checkers. Who makes the call, right? How does that get done? Facebook has this quasi-independent panel, right? Is there, and where does it go? Where do you stop with kind of the determination of whether this is bad and get to the liability question of, okay, now it ends up in court. So how does that, what are the practical, and not just for operationally, but for research? Can we see, as you were talking about, Peter, what kind of content do people have to deal with? Because legislators in particular have no clue about the content issues that you're in the middle of, Mariana, and the subtleties and the difficulties of this. So, Peter, you want to start?
Yeah, let me, and I think my answer will be very partial, so Mariana will have to correct my picture a lot here. That first, platforms are per se, we consider them not as editors of content, but de facto they are. So legally we do not consider them, but de facto they are. They choose what to amplify, they choose what you see. So there is you can say, an editorial function in their algorithm. And I think this is where you have to start. And you say researchers. Researchers need to understand how this information works, needs to understand how this content is coming together. Right now, we do that on a one-by-one basis. We see something, we track it. Oh, is that sort of Russian disinformation machinery spitting it out? That's maybe useful, but that's not an effective way of dealing with the issue. We need to go step back, needed a whole host of body of content, understand that. And artificial intelligence, I just want to mention it, not go any further into that. There are a lot of tools already coming along which will help us to minimize the problem. It will never go away. All we want is sort of to take it back to a level where it doesn't jeopardize society. That's all. I mean, if there will always be a certain noise in this system, but it shouldn't be just too much. And I agree with you, Bruce. I think, I don't think we have fully understood on what the levers are and how we turn them and what the optimum situation is. But we need those levers and the knobs to turn. Otherwise, we'll never figure out what the right way is.
Mariana?
Okay, so just for fun, I'll start by disagreeing. I don't think we can properly say that digital platforms are editors. I think they have editorial functions because I think they're different from the traditional editors. And I think it's really important when we're thinking of regulation that we look at what's different, that we look, for example, at algorithms. If we just think of them as editors, we could think of, I've seen simplistic solutions being adopted by judges, for example, requiring a platform to provide for a right of reply, let's say. That's something that you do with a traditional editor, and it doesn't make any sense if it's just put like that, right? Because the reply never reaches the same number of people that the first piece of content reached. So it's a different kind of thing, which doesn't mean that it shouldn't have liability and shouldn't be regulated. How to regulate it the way it is, right? And I have an example, which I think is interesting. It goes a little bit beyond social media. In Brazil, WhatsApp is something really big, right? I mean, almost more than 90% of the population use WhatsApp. And it's believed to be one of the most important driving forces of disinformation in the country because of the way it works, right? Because it's encrypted communications, because you can't see what's there, you can't take down content. And one of the things that started to be discussed was how to find intelligent ways to regulate WhatsApp, thinking of this disinformation context without breaking encryption, because it's also very important to users, right? And then when I was mentioning regulating the architecture, we have an example there. One of the things that this fake news bill does is trying to limit some functions that these kind of encrypted apps can have, understanding that if you're an encrypted app, you can't be at the same time a broadcaster, right? Because it's incompatible. That's the understanding. And I think that's an interesting way to look at this problem. And also in the last election, bulk messaging on WhatsApp got prohibited, which was one of the issues before, using external technologies to bulk message other people on WhatsApp. So, I mean, there's multiple ways to look at this, right? And I think that's looking at architecture, understanding these technologies for what they are is really important for regulation. I think they're somewhere different from traditional editors, and this kind of regulation shows it.
And I love your point about bringing in here at the last minute the whole problem of encrypted social, conversational messaging apps. I mean, we could do a whole nother seminar on that. We'll invite you guys back, but because that's definitely a can of worms. I guess with the time we have left here, last question from the audience. So let's talk a little bit about remedies. You mentioned that liability, Mariana, liability occurs, can be generated after words for some bright line cases. But in general, what are the remedies? I mean, in many situations, it's like the damage is done once the words have been said. So what are reasonable or meaningful remedies for people in this case? You want to start, and then Peter, you can have the last word before we turn it back over to Michael.
That's a very good question, and I think it's a very hard one to answer. What's available out there for people, right? And I think in many cases, the first thing that comes to mind is financial repair. And as you mentioned, Bruce, that's not always going to be effective or what the person wants, right? Because we're frequently speaking of damage that ruins a person's life. So I was speaking earlier of dissemination of intimate images, for example. That's something that we have multiple stories of how that's ruined people's lives. So of course we can speak of repair from platforms, from the individual subject, but one of the things we have to start thinking more of is other forms of bringing justice to the table, right? So for example, restorative justice, thinking of administrative bodies that are able to reach different solutions that address people's concerns and needs other than just like civil remedies and criminal law and all that. And I think some of the legislation being proposed around the world looks at that, right? At trying to find particular solutions for people who have suffered harm online. But I think many of the legislations that we're discussing here are also looking to prevention. And I think that's very, very important because, as you said, in many cases, it's just so hard to find repair to situations. And we need to be looking at those sides, at both those sides, I think.
Great. Peter?
I would like to approach it only from two sides for the moment for simplicity reasons. I think really severe cases, and in Europe, you have lots of defamatory cases going through the court system, and there will be just a court decision and then platforms execute that within a very short period of time. So that is functioning, but that's just sort of this visible top of where harm or where greater harm occurs. We also realized in our 5 years of work that many consumers, they would like to have a meaningful mechanism to interact with the platform. They realize this is wrong, this is harmful, I don't like it, and it's wrong. But it's not necessarily harmful in the level that you say you're going to take great action. But you need to have a meaningful way to interact with the platform, because that would allow, or does allow in Europe, the platforms to tag the content. It just puts a sort of a question mark on a piece of content and will change the way this gets amplified. And many people are just happy if things get forgotten. If you can just make them go away, that's already a great thing. And without necessarily going into the precise discussion, who is right of the two. Because if you do it like that, you still respect the freedom of expression of the other party. And, nobody can stop me from going down on the street and calling everybody whatever I want. At least once I can do that. So we need to treasure that ability as well, even if it goes on board. But at the same time, there's no need for that more than 5 people are listening to what I say. So, and I think, as Mariana said, it's not easy to answer that question. But the less litigation, the better for everybody.
Great. Well, I don't know, that doesn't seem to be the American sport, but I personally agree with you. So you'll notice on the Q&A that a lot of links have been put up. Those links will also be available on the WFLS and Stimson websites. So check it out. Lots of good research and resources for this conversation. Michael, take us home.
Thank you, Bruce. Lots and lots of food for thought today. So thank you so much to our 2 amazing panelists, Mariana and Peter, for this informative and very timely conversation. As Bruce mentioned, the resources will be available on both our websites. Thank you to our audience for following. Do remain engaged with us. We'll have other events, both at Simpson and the Washington Foreign Law Society in the Cyber Series.